minutes for rebuttal, so if you want to reserve any time, let me know, and I'll give you a hand signal when we reach the clerk.
Thank you. May it please the court, my name is Arthur Axner, and I'm the attorney for John Parker, who is the appellant in this case. There are two issues which Mr. Parker is presenting to this court for review.
Do you wish to reserve?
I'm sorry?
Do you wish to reserve any time?
I'd like 3 minutes, Your Honor, please. There are two issues that Mr. Parker is bringing to this court for review. The first issue pertains to the property division formulated by the trial court specifically with regard to the court's decision denying his claim for separate property. And the second issue pertains to the award of spousal support, which has now been paid for since June 2014. Documentary evidence in the form of checks issued by Frank Parker, John Parker's father, and by Edward Parker, John Parker's brother, as trustee of the Parker Family Trust, and the testimony of both John Parker and his brother Edward Parker established that when Frank Parker was still alive, he was gifting money each month to John Parker, and those funds ended up being invested. Ultimately, those funds were ordered by the court to be placed in my trust account where they sit to this day. The second part of the property division, which is at issue, are a series of checks that Frank Parker issued to my client from life insurance money paid to him as beneficiary of his father. So in the trial of the case, those issues were presented to the court, and the court concluded that they were marital monies and not separate monies. The decision by the trial court that those funds are marital funds is against the manifest weight of the evidence, and the court order must be reviewed because there is no other evidence in the record to counter the claim that my client was making that those were his separate monies. That is the only competent, credible evidence in the record to support that claim. And for this court's information, the second account is a Charles Schwab account, the last 4 digits of the account number being 7299. The second issue pertaining to spousal support raises 2 questions. I submit that the award is contrary to law because Pamela Parker did not request a spousal support award both in the original counterclaim that she filed in this case and in the amended counterclaim. An award of spousal support was thus not a triable issue in the case because a demand for judgment of spousal support was not made. Civil 8A, which provides for claims for relief, states that a demand for judgment for the relief to which the party claims to be entitled must be made. And this court has addressed Civil 8A in several cases, including the Kreider case, which I have not cited, but I have since found. The second branch of the spousal support issue deals with the analysis that the court gave to both of these parties. The record will confirm that both parties were discharged from their employments during the pendency of the case. John's discharge was for poor performance. That's what his employer said. Pamela's discharge was because she had a disagreement with her parents pertaining to the operation of a family party center in Broadview Heights. The finding by the court that John had intentionally diminished his income for spousal support purposes is not supported by the evidence, especially since spousal support was not a triable issue. Throughout the marriage, Mr. Parker worked long and strenuous hours to support his family and establish a home environment for them. When the court issued temporary orders, he readily complied. When a partial property division was reached, in this case, on the record, Mr. Parker readily complied, including payment to Mrs. Parker of $38,170 by lump sum payment for her equity in the marital residence. There is simply no basis in fact for the court to denigrate John's credibility by suggesting that by design he was motivated to avoid the monetary obligations even though he suffered a diminished income by virtue of his change of jobs. By contrast, the court did not see fit to denigrate Pamela Parker for her loss of employment. She was the one who voluntarily vacated the marital residence, and she was the one who abandoned all obligations with reference to it. She was the one who gifted shares of stock that she owned in the family business to her mother and father without being compensated. The court saw fit not in any way to criticize her actions. The only comment that the court made with reference to her was that she would return to her employment at the Party Center as its manager when the divorce was final. Although not part of the record, that is exactly what has transpired since the conclusion of the case. At the time of the divorce, Pamela's income was greater than her husband's. The court abused its discretion when it ordered John to pay spousal support. He has been placed in a position of not being able to service his indebtedness and support and maintain himself and the child of which he is the custodial parent. I believe the court was conflicted because when you read the decision, for child support purposes, the court specifically did not impute income to either party, but calculated child support based upon actual income. The court, by implication, concluded that John was not voluntarily underemployed. This court has stated that spousal support statute does not direct the court to consider potential income of a spouse. This court has also stated that the spousal support statute does direct the court to consider the party's actual income. The court has also stated that the court should not impute income for spousal support purposes. In this case, the court in effect imputed income to John upon his income from his employment when he years ago worked for a company called J. Parker and Sons. It did so with suggesting that it was considering his earning ability. If John could earn $52,000 a year, as the court concluded, the question becomes why would he struggle to financially support himself and his child and maintain the indebtedness which he has to this day. Support is not appropriate and reasonable, and the court respectfully must reverse that award. Thank you.
May it please the court. My name is Sunny Simon. I represent Mrs. Pam Parker. With regard to the first assignment of error, the record is clear that there was credible, competent evidence supporting the trial court's finding that the two accounts Mr. Parker claims were his separate property were marital accounts subject to equal division. Specifically, it's clear that Mr. Parker...
It traces it all back?
Pardon me?
It traces it all back to separate property?
It does not. The court found that it was marital property and that Mr. Parker failed to meet his burden of proof, which is his, which he must do. The court assumes and establishes property is marital unless it's proved otherwise, and Mr. Parker clearly failed to trace the monetary gifts he received from his now deceased father to funds held in one account, in his attorney's trust account, The second account is a Charles Schwab account. First, with regard to the trust account, there's approximately $82,000 on deposit there now. The trust account funds originated from 3 universal union security life annuities established through Mr. Parker's former employer, Sons Packaging, Inc. The annuities were funded during the marriage between 2001 and 2011. However, Mr. Parker claims he paid his employer $800 per month for the premiums from funds he received from his father. However, testimony that the annuities were funded with these gifts, it doesn't support this. Specifically, Mr. Parker points to Exhibit 38, which is a series of checks Mr. Parker's father wrote to Mr. Parker, some in cash, some to him in his name. These checks were written from 2001 to 2005, and remember that the premiums were paid from 2000 to 2011. The series of checks, however, are never traced to the annuity. Mr. Parker claims he took cash from these checks and handed them over to his employer, her former employer, and that's how these were funded. There are no receipts that were presented at trial. There's no canceled checks. There was no testimony from his former employer to come in, a secretary or somebody, to say, yes, I received $800 in cash from Mr. Parker every month for these 10 years. No evidence was presented.
So no one went back to the bank to get a listing from the bank of the checker, of the check?
There's checks. There are checks that were presented at trial that totaled $6,400. But these checks there's no nexus between Mr. Parker simply receiving $6,400 and using these funds for the purpose of paying premiums. There's just no nexus, and that's the burden of proof that Mr. Parker must meet.
Is there a dispute whether or not the premiums were paid?
There's no dispute.
So I think his argument, if I'm understanding it correctly, is there's also, in addition to there being, or you can see that there's no evidence that these particular checks were used to pay those particular premiums, there's also nothing brought forward to show where else it could have come from, if you look at the parties' monies throughout the preceding relevant period of time.
Thank you. I'll address that. First of all, Mr. Parker's father died in 2005, I believe, and the premiums continue to be paid. The trial court found specifically that Mr. Parker was earning sufficient funds at his jobs during that time. He was earning in excess of $74,000 to be able to fund these premiums. So the trial court did find that there was sufficient income coming in from Mr. Parker's jobs. The Sons Packaging job, the trial court record reflects, is a second job he had. He was working at another job called there was another job he had, so we had 2 jobs. One main job and also the Sons Packaging. And with that Sons Packaging income, the court found that there was sufficient income to fund these premiums. So they continue to be paid even after his father died.
So there's, in the record, there's a trail or a lack thereof of where this income went after it was paid to Mr. Parker, where the income.
The income from these several checks was only $6,400. I don't
The income
know.
from his job.
There's no tracing of where income went from his job.
Okay, that's the question. Thanks.
Second account is a Charles Schwab account. There's approximately $23,000 there. Mr. Parker argues that he used monies from 3 checks written, Exhibit 34, written from his brother that for funds received from their father's life insurance policy. The checks total about $15,000. Mr. Parker again failed to show that when he cashed these checks, they actually went into the Charles Schwab account. There's no nexus again. It's not enough for Mr. Parker to come in and say, I received $15,000 from my now deceased father, or that I received money from the other checks for $6,400. He has the burden to show that he actually took these monies and put them into these 2 accounts. He doesn't do that. Mrs. Parker, on the other hand, presented evidence at trial on the Schwab account and these checks and showed specifically that Mr. Parker deposited the $15,000 he received from his, the life insurance policy into a First Merit account. The trial court found from the evidence that this money was then commingled with marital funds, and more than that, Mrs. Parker was able to show that Mr. Parker withdrew cash out of his First Merit account. And that was the end of these checks. That was the end. There was never any nexus that Mr. Parker took cash out of First Merit and then put it into this Schwab account. It just never, the evidence just simply isn't there. The court assumes that the statute assumes this money is marital, it was earned during the marriage, and it's going to be marital unless there's some traceability from these separate funds into these two accounts. It wasn't happening, and I would argue that it would have been against the manifest weight of the evidence to the trial court to hold otherwise, to hold it that these accounts were other than marital. The second assignment of error, with regard to the request for spousal support, the trial court did not abuse its discretion by awarding Mrs. Parker spousal support in the amount of $600 for 70 months. Ohio Revised Code Section 3105-18B grants the trial court the power to award spousal support upon request of either party. Mrs. Parker made such a request for spousal support on April 19, 2012 in a written motion. 3105-18 does not require that this request be made in a complaint or counterclaim. Even in the event that Mrs. Parker did not make the request, which she did, the Ohio Rules of Procedure, Rule 15B, allows for an award of spousal support because the issue of spousal support was tried by the express and implied consent of the parties. The parties' testimony addressed the statutory factors in 3105-18, and the parties both submitted voluminous financial employment records relevant to the spousal support request. Mr. Parker was on notice of the request. It was in Mrs. Parker's pretrial statement. She made a written request, and he never objected to this evidence coming into trial. The evidence addressed all of the factors. Consequently, Mr. Parker waives his right now to raise this objection. In addition, the trial court specifically stated it followed and considered the factors in 3105-18 when concluding that the award of spousal support was appropriate and reasonable. According to Fisher v. Fisher, this is sufficient to uphold the award. Further, this court in Peters v. Peters allowed for an award of attorney fees to a spouse when it was not requested in anywhere, which is even different, distinguished from this situation where it was requested, because it was implied by the trial by the implied consent of the parties. The third assignment of error, also with regard to the record being supported, the trial court's finding, Mr. Parker purposefully and significantly diminished his gross income to avoid payment of spousal support. This is supported by the record as well. The court also found that his earning ability is $52,000 a year. Mr. Parker argues that the trial court erred because it only addressed his earning ability and not that of Mrs. Parker. This isn't true. The record states specifically to the contrary that the court did address Mrs. Parker's earning ability. Specifically, the court found that Mrs. Parker's earning ability was $36,785 per year, based on Mrs. Parker's average income over 5 years. So this was addressed. In addition, Mrs. Parker's earnings at trial were only slightly lower than that which she was earning at the beginning of the trial, which is much different from what we saw with Mr. Parker. The court then considered Mr. Parker's earning ability and found he did purposefully significantly diminish his gross income to avoid support, and these findings were consistent with the evidence at trial as well. First, the evidence showed that Mr. Parker earned an average of $74,000 per year from 2000 to 2011. Mr. Parker was working at Kuzmin's at the time of the divorce, earning $52,000 plus earning a $700 subsidy every month for health insurance coverage. Mr. Parker also had his own company called DeckPro, where the evidence showed he had income coming from that business. He also had a side job delivering produce to a school. Mr. Parker's income then, during the divorce, took a drastic and deep dive to $16,000 approximately. The court found from the evidence that Mr. Parker was fired from Kuzmin's and quit working his own business at DeckPro during the time of the divorce. Mr. Parker testified that he gave up DeckPro because there wasn't a need for him to kill himself out there and work like this. Joe Boda, the former manager at Kuzman's, came in to testify that Mr. Parker was terminated for poor work performance. After Mr. Parker was terminated or warned and put on notice, Mr. Boda testified that Mr. Parker continued to arrive late and leave early. Contrary to Mr. Parker's argument that the law does not allow for the trial court to consider a spousal earning ability, the statute specifically provides this. And further, the court in Collins elaborates that if one spouse has substantial earning ability and the other does not, then the disparity will be a factor to be considered with the other statutory factors when arriving at a spousal support award. The trial court found in this case there was a disparity between Mr. and Mrs. Parker's earning ability, and the court in Collins further clarifies.
I believe my colleague had it. But my question
I'm
is,
sorry.
is earning ability, where does earning ability equate with imputing income to? Where do we get the right to, where's the trial court right to impute income to when the real issue is earning ability?
There's two separate analyses that go on when one looks at how to determine the child support award. Collins clarifies that first, that there's no prohibition against imputing income to a spouse for purpose of formulating a spousal support award, but it's different from the analysis when you impute income in a child support case, because the overriding objective in a child support case is to provide for the best interest of the child and the responsibility of their parent to the child. So the analysis with regard to earning ability is just one factor that juxtaposes each spouse's ability to earn money. It's how they relate to each other, which is different specifically from the child support statute, which insists that if a party is, a finding that a party is underemployed voluntarily, that the court must impute income to the child support worksheet, a specific amount. But the factors and the statutory factors in spousal support don't insist on in ascertaining a particular amount of money. But at the same time, Collins states that the amount of money imputed in spousal support when analyzing relative earning ability still must have a context, and in this case it does. The trial court used the $52,000 that Mr. Parker was earning at the time of the divorce. So the analysis is different. The earning ability is only one factor that relates the potential for both parties. But with child support, it's a different statute.
When you use the word context, you're talking just about the circumstances of the parties.
The actual income that Mr. Parker was
Right.
earning.
And does the statute give any further guidance as to the limits of how much of that money can be appropriated for child support? What's needed for living expenses? How is the judge to make that decision?
With regard to the spousal support award, the trial judge referenced and addressed all the statutory factors in formulating the spousal support award. And when Mr. Parker claims he can't live and he can't pay bills, the court heard evidence throughout the whole trial that he willingly stopped working at his own business, he stopped delivering produce, he got terminated from his job for poor work performance when the manager did come in and talk about why that happened, and he was giving warnings. So
you eat what you kill, and he didn't kill anything.
pardon me?
The old adage, you eat what you kill, and when he abandoned his employment, he virtually killed nothing.
I think the court just looked at the fact that he had the ability to earn more. So, and the trial court was in the best position to hear the testimony of the witnesses and assess their credibility. And further, Mrs. Parker did not leave the house voluntarily. The court ordered, the magistrate ordered her to leave because the marital home sits upon the land that was owned by Mr. Parker's family. So Mrs. Parker had to leave.
And now, if you just conclude quickly, you're out of time.
Thank you so much. The trial court did not abuse its discretion by awarding Mrs. Parker spousal support.
Thank you.
Thank you.
We will take the matter under advisement. Oh, I'm sorry.
I just
You
have
have
a
3
couple-
minutes, don't you? Yes,
I
you
won't
do.
take 3 minutes, Your Honor.
Well, I'll give them to you.
On the issue of spousal support, the council quoted the spousal support statute. Within 3105.18B, when they talk about spousal support, it says upon request of a party. And once again, the wife in this case did not request spousal support. Secondly, earning ability is but one of the factors for the court to consider. We don't know what other factor the court considered, other than she looked back at the history of my client's income when he worked for J. Parker and Sons and Sons Packaging. At the time this case was filed, prior to the time this case was filed, my client no longer worked there. He worked for the company in Cleveland called Kuzman's. With reference to the property division, I would only ask a question. Mr. Parker, I told you earlier, worked long and strenuous hours to support his family. He did not earn enough money from that job to have accumulated over $80,000. That's an issue in his claim for separate property. He did not earn enough money. He could not have accumulated that money, but for the fact that his father was gifting funds to him. And I guess the question is, since his father is dead and we could not come up with all of the checks, is he to be punished for that?
How was it funded after his father died?
Pardon me?
How was the children's free accounts, how
It's-
were
it
those funded
stopped.
after his father died?
It stopped.
So no more payments made
No,
after
no,
2005?
but then his brother, who was trustee of the father's trust, distributed monies, including 3 checks, which I think are on Exhibit 33 on the second Charles Schwab account. Those were life insurance monies on the life of the father. And the monies went to Edward Parker, and Edward Parker in turn distributed them to his brother John.
The money went to the brother.
The money went to the brother,
It was devised to the brother.
and the brother distributed.
And the brother voluntarily gave it, or was he under an obligation to give it?
I don't know, because I did not have the trust agreement before me, but he was the trustee of the trust, and he was a witness in the case. Thank you very much.